Do grandparents have rights of contact or time sharing with their grandchildren in Florida? We're talking about legal rights. We're going to talk about, are there other options other than trying to seek legal rights? And hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So, everyone's probably heard that grandparents do not have any legal rights with regard to forcing time sharing or contact with their grandchildren against the wishes of their grandchildren's parents. So, what are some options here? Because you can't sue directly for grandparents' visitation, contact, or time sharing rights. So number one, the most obvious, the best, if you have a decent relationship with your son or daughter, then seek to get time sharing during their time sharing or contact rights as awarded by the court. Now, if they are estranged, you don't have a good relationship with them, you can try to resolve that by offering perhaps to help out with private school tuition for your grandchildren, to buy them clothes, pay for some meals, do something to get back in good with your adult son or daughter, if, of course, their ex is not allowing you to have any time sharing. So that doesn't require any legal intervention. It wouldn't cost you to pay attorney's fees. You can weigh that, how much you would have to pay an attorney to try to get something done versus just paying something that's going to directly benefit your grandchildren. So number one, try to get that worked out with your own son or daughter to see your grandchildren. Number two, maybe a little bit more difficult. Of course, it depends on the circumstances, but try to seek to improve the relationship with your son or daughter's ex in order to get time with your grandchildren. It may take a load off them. You may offer to be free babysitting, or childcare, depending on the age of the children, of course. Again, you can offer to pay for some private school tuition, maybe some daycare expenses, meals, clothes, whatever. It's a much better expense or investment than necessarily paying for an attorney. Okay? So number three, if you believe that your son or daughter and or their ex-spouse or significant other, the other parent, are either unfit, abusive, neglectful, have abandoned the children, then you can seek intervention through DCF, and you can make that allegation of abuse or neglect or abandonment. And then DCF can come in, and if DCF determines that the children are at risk, the DCF can take them into either foster care, but that's not what you want. You want to offer, as part of the case plan, to offer that you will take care, as the grandparents, you will take care of your grandchildren, and you'll have a significant advantage over anyone else if DCF determines, again, that either or both of the parents have been neglectful, abusive, or have abandoned the children. I'm going to say that's a difficult road, and you're kind of in the system at that point, and DCF can be incredibly slow, difficult to work with. You don't have anybody there that's really giving you much in the way of information of what's going on in the case. So it has to be very egregious, really, for DCF to get involved. And you can, yes, retain counsel to assist you through the process and navigating the whole DCF labyrinth to get to the case plan that gives you that time with your grandchildren. But again, very difficult. All right, the next, fourth option is a private guardianship, where you try, well, you're going to need counsel for this most likely, to go to the court rather than directly through DCF, and ask the court to make a finding that the parents have either abandoned the children or abusive or neglectful. But then DCF would likely get involved, and you might be back into the DCF system. So that avenue can be difficult depending on the circumstances in your case, how egregious the situation is, who the judge is. There's just a lot of different factors that go into that. So finally, there's something called, your fifth option is a Chapter 751 guardianship. It's a temporary guardianship by extended family member. So I do that a lot for legal aid cases, some for private cases, but that's typically where mom and dad are either out of touch, I'm sorry, but they're, on the streets, on drugs, in jail, even sometimes have already passed away, and nobody's really there to take care of the children. One of the parents, or both if they're both still available, can give a consent for you to have a temporary guardianship of the children, of the grandchildren, for a period of time while the parents are getting back on their feet. It's not a real expensive process. It's a fairly straightforward process. Judges love it because it's better for the grandchildren to be with their grandparents rather than to be in the foster care system or somehow in the DCF system. So those are the 5 options. Of those 5, I'm really a believer that if you can work things out with your son or daughter to see your grandchildren, or with the ex, and you can kind of navigate that. You can get advice of an attorney in your specific situation, what might be the best course for you to take under your particular circumstances. But those are generally the 5 ways that I would recommend that you try to gain time with your grandchildren. Okay, so even though Florida law does not recognize grandparents' rights to sue for in state court, there are these other options. All right, I hope this has been helpful. Hope you've enjoyed this. Please, if you found value in it, hit that like button, subscribe to the channel. Leave me a comment if you have a question or even a topic for a future video. This video came from a comment or a topic that was left by a viewer. So thanks so much and have a great day.